Yeah, I'm Larry Tribe. I guess my official name is Laurence H. Tribe, and I'm the Carl M. Loeb University Professor at Harvard Law School and Professor of Constitutional Law. In the chapter on Citizens United, we begin with Stephen Colbert. How could we not? I mean, Stephen Colbert was a formidable adversary of the Supreme Court. They were outmatched. They came to this gunfight with barely a knife. And he did a good job of caricaturing the court, making it look like the court was holding that corporations are people. You know, we know that they don't cry, they don't love, they don't make love. How can corporations be people? And that money doesn't influence politics. It's easy to make fun of the court and to make it look like its invalidation of campaign finance reform was simply an exercise of sort of preference for oligarchy and for wealth and for corporate power. But in the chapter on that subject, we show that it's way more complicated than that. That even if you don't regard corporations as people, and frankly I don't, that there is a danger of having the government silence a corporation when it wants to spend money on an anti-Hillary movie, or for that matter, an anti-Sarah Palin movie or an anti-McCain book. There are dangers in having the government decide who is entitled to speak and who isn't, who's speaking too much, how much speech is exerting too much influence. I mean, those are things that are scary. It's not a happy thing for democracy that people with power and wealth can just multiply that power and wealth by using it to gain access and influence. And we talk a lot about that in the book. But it doesn't follow that giving government the power to tune down the speaker on the very wealthy is the solution. And it, in fact, is part of a very strong tradition in our constitutional history. Although it doesn't go back to the very beginning, it's really something that has been given life only since the 1940s. It's part of a very strong tradition that we are properly suspicious of the government when it tries to decide who is influencing discourse too much. I mean, if a spaceship were to suddenly land in Lafayette Park across from the White House and start influencing citizens on how to vote, and if the government were to pass rules saying spaceships aren't people, they can't, even though they've gotten their hands on money, they can't spend it on speech because we don't want them to influence us, we would say that's government censorship. And it wouldn't help to have a constitutional amendment saying spaceships are not people. So that's what we do with Citizens United. We show it's a much more interesting and difficult and fascinating problem than most of the people who pontificate about it seem to think. Well, one of my early experiences when I was clerking at the Supreme Court was to work on an opinion in a case called Katz versus United States, where the Supreme Court said that the Fourth Amendment protects people, not places. And what it meant by that is that even if the government doesn't sneak inside your house or stick a wire inside your lapel in order to overhear you, if you have a justifiable expectation of privacy and they are violating it, then that should be subject to constitutional control, typically under the Fourth Amendment of the Constitution. That decision was important in connecting the right of privacy to communication. What the court said was that if the government gets everybody to expect that Big Brother is always listening, the way some of us now with the NSA metadata program have begun to expect, then people will not feel very free about their communications. Communication will be inhibited. Speech is involved here, the First Amendment as well as the Fourth. And a few years after that decision, the court, I think, made a big mistake when it said, with respect to a particular little new technology called the pen register that could be attached to someone's telephone and could let the government know, let Big Brother know every number that was being dialed. When the court said, hey, that's not private, you don't have any expectation of privacy there, you've already let your phone company know the number you're dialing, so it's no big deal to have Big Brother know. That was a big mistake. Justice Stewart, for whom I clerked when we worked on the case of Katz versus the United States, the case involving the Fourth Amendment protecting people, not places, he dissented in that case. That's what's coming before the court now in an issue involving cell phones that's going to be decided this term. And in the metadata collection issues of the NSA. It's true that when we have an information service provider with our smartphone, we know that it gets information about all the websites that we're visiting and all the emails we're sending, but it doesn't follow, or it shouldn't follow, if free speech is to remain the rule in this country, that the government knows it all and that we should be entirely satisfied to have the government learn it. The court has had these wonderful cases in recent years that we discuss, humorous cases and interesting cases, scary cases about DNA collection, about attaching a GPS to your car. That's another good example of why it was important to write the book. People tend to assume that liberal and conservative sort of line up in the same way on different issues. Well, it turns out that on privacy, Justice Breyer is considerably to the right of Justice Scalia. And it turns out that when the court was grappling with the case in which the FBI attached a GPS to the bottom of this guy's Jeep and followed him for a month, all 9 justices had no trouble coming out with saying that, hey, that's a search and it needs government regulation, it needs to be subjected to the warrant requirement. It was clear from the beginning of the argument that it would come out that way. I mean, Roberts basically said to the hapless lawyer for the government, do you mean to say that if you were to attach a GPS to my car, you could follow me or any of my colleagues for a month? And the poor guy had to say yes. He couldn't have said, oh no, Your Excellency, you are immune to the laws of the Republic. So it was clear they were going to come out that way. But how and why? Scalia came out that way because the GPS was attached to the guy's property. It was as though the Fourth Amendment protects property rather than people. Alito said, what are you talking about? It doesn't matter that it was attached to the Jeep. It wouldn't have been any different. It might have been worse if it had been tracking him from a remote location. And then they had this wonderful jousting back and forth in which essentially Scalia says, but there is a fundamental principle we want to preserve. We want privacy to be as strong now as it was in 1791. And Alito basically says there was no analogy in 1791 to the global positioning device. And Scalia says, sure there was. Just imagine a guy in a carriage or in a coach and a constable hiding and following him around and figuring out where he's going. And Alito basically says it would have to have been an awfully large coach or a really tiny constable, or at least a constable with enormous fortitude and patience. Well, it's that kind of jousting over new technology and how the law should handle it that figures over and over again in our discussion of privacy. Sotomayor seems to be about the most tech-savvy of the justices, although Kagan isn't far behind. She tends to rely a little more on her law clerks. Sotomayor argued in this GPS case that it's the doctrine of that old pen register case that now perhaps needs to be reconsidered. We need to reconsider what is called the third-party doctrine, the doctrine that says that when you turn your information, your private information, over to someone else, like the phone company or your information service provider or Google, that you automatically take the risk that the government is going to learn it. So the court is grappling with these new technologies, and the justices have very different attitudes toward them. In one public address, Justices Ginsburg and Scalia, who often disagree but are great buddies when it comes to opera and sort of general conviviality, we're talking about the inevitability that the NSA's program of collecting all the emails that any of us send, or at least the addresses to which we email and the numbers that we call on our cell phones, they had a very different attitude toward the prospect that that issue would come to the court. Justice Ginsburg essentially welcomed it. She said, we have to grapple with this. It's important to people's privacy. That's important to people's control over their whole lives and who they are. And Scalia said, it's really a great shame that we're going to have to grapple with that because we don't know squat about high technology. He even in one case involving genetic manipulation concurred only in part with an opinion by Justice Thomas on the ground that he didn't really understand the science. So science and technology is going to figure very importantly in the future of how the court grapples, not only with privacy, but with other rights.